Okay, let's unpack this a bit. Imagine a serious felony arrest just hanging over your head, casting this, long, heavy shadow over everything, your future. Now, picture a specific legal path, one that allows the law to actually erase it, completely wipe it from your official record. Sounds almost, too good to be true, doesn't it? But in Texas, for certain very specific situations, this path is absolutely real. Today, we're doing a deep dive into Texas felony expunction. And this isn't just, theory about clearing a name. It's about understanding the clear, precise rules laid out in Chapter 55A of the Texas Code of Criminal Procedure. Our mission today is to take this legal language, which can feel pretty complex, and distill it down. Make it into clear, empowering insights for you, our listener. Insights you can really use. Our guide for this is Sean Lacey, also known as Ms. Officer. That's pronounced Ms. Officer, from Legal Gangsta. Her work, it's all about empowering everyday people with real, practical knowledge about the law.
Yeah, and what's really compelling about this area of Texas law, I think, is just how deliberate it is. How it provides these opportunities for a genuine fresh start. It's not just some vague hope, or like a loophole. It's a series of clearly defined pathways. And if you navigate them successfully, they can genuinely change the direction of someone's life. It really speaks volumes about the justice system's capacity for, correction and rehabilitation.
Okay, so let's start exploring. The first scenario, this one seems, arguably the most straightforward. What happens if you've been accused of a felony, you went through the whole trial process, and the judge found you definitively not guilty? What does the law say about those records, from the arrest?
They still exist, right? This brings us to Article 55A.002.
Right. Article 55A.002 gives a really clear answer here. If you've gone to trial for the offense you were arrested for, and the trial court found you not guilty, acquitted you, then you are legally entitled to have all records and files related to that arrest expunged. It's not a discretionary maybe, it's a mandatory must. Okay. That's a crucial distinction then. It's not just about walking free from court, it's about truly wiping the slate clean. I think a lot of people might assume, hey, found not guilty, the record just vanishes. But that's not how it works automatically, is it? So what's the practical difference between just being acquitted and actually getting your record expunged under this article?
You've really hit on a critical point there. An acquittal, it means you're legally innocent, sure. But the arrest record itself, that often stays in various databases. It can be accessed during background checks for jobs, housing, even like professional licenses. This article, 55A.002, it acts as the legal firewall. It means once you've been proven innocent in court, the system gives you this robust mechanism to genuinely clear your name. Not just avoiding conviction, it's really about making sure that the digital footprint of that arrest doesn't keep creating barriers in your life. Imagine applying for a job years down the road. Without expunction, that arrest might still pop up, even though it ended in an acquittal. This law ensures a true fresh start.
Wow, that really does sound like a lifeline. But okay, what about those incredibly tough situations where someone was convicted, but then, later on, the truth of their innocence finally comes out? This brings us to a more complex, but equally powerful scenario: expunction after a pardon for actual innocence. That's covered by Article 55A.003.
Yes, this article addresses those profound injustices. It allows for expunction if someone was tried and convicted, but then later received a pardon or some other relief, specifically on the basis of actual innocence for that offense. The absolute key here is that the pardon itself, the document, must clearly state it was granted because the person was, in fact, innocent. It's not enough if the conviction was just overturned for, say, a technical reason. It has to be a definitive finding of actual innocence.
Okay, so the bar for this type of expunction is incredibly high then. It needs that clear, explicit declaration of actual innocence from the pardoning authority. This really underscores the justice system's commitment, or at least its aim, to correct its gravest errors, doesn't it? It feels like it's not just about legal procedures, it's about making right what was fundamentally wrong.
Absolutely. This provision, it really highlights the legal system's recognition of, human fallibility, and its commitment to correcting fundamental miscarriages of justice. When someone has genuinely gone through a wrongful conviction, making sure the official records reflect that exoneration is just paramount. It's a vital mechanism, not just for that individual's justice, but really for maintaining public trust in the system too. It shows that even after a conviction, there's a path to full vindication and clearing your name when true innocence is proven.
Right. Okay, and what if a pardon does come through, but it's not specifically stated as being for actual innocence? Does Texas still offer a path to expunction in those cases? Let's explore Article 55A.004. This one outlines expunction for pardons granted for, well, other reasons.
Yes, it does. Article 55A.004 broadens the scope quite a bit, actually. It says if you were tried and convicted and then later pardoned for that offense for any reason other than actual innocence, you are still eligible for expunction. So this means the specific reasons behind the pardon are less restrictive than in that previous scenario we just talked about.
That seems like a much wider net then. What kind of other reasons might lead to a pardon that then qualifies for expunction, even if it's not strictly about innocence? And what does this particular article tell us about maybe the state's broader view on second chances?
Well, these other reasons could be things like exceptional rehabilitation demonstrated over time, or maybe extensive time already served. Sometimes it's a significant change in the law that, looking back, makes the original conduct seem less severe. Or it could even be just gubernatorial discretion, for compassionate reasons. For instance, a governor might pardon someone who's shown absolutely exemplary conduct for decades after release, even if the original conviction was, factually sound at the time. So this provision, it really demonstrates the state's broader approach to rehabilitation and offering paths to redemption. It acknowledges that sometimes a conviction shouldn't be the final word on someone's life path. It's about recognizing growth and providing ways for people to fully reintegrate into society without that permanent stain on their record.
Okay, now let's shift gears a bit and look at a very specific legal change, one that actually created a new opportunity for expunction. It's a fascinating example of how legislative updates can bring relief. This is Article 55.005, dealing with the unlawful carrying of handguns under an old law.
Yeah, this article is indeed very precise. It applies if a person was tried and convicted of the offense of unlawful carrying of a handgun under Section 46.02a of the Penal Code. But, and this is the key part, as that section existed before September 1st, 2021, that date is absolutely critical. The offense had to have been committed before September 1st, 2021. That's the date when Texas enacted its constitutional carry law, which, generally allows eligible citizens now to carry handguns without needing a license.
Right. So essentially, someone who was technically breaking the law under the old rules, committing what was then a felony, isn't considered to be committing that same offense now because the law changed. And the state provides a direct legal way to wipe that specific conviction clean. That's a really compelling example of how law changes can retroactively affect people's records.
Precisely. It shows how legislative updates can provide that retroactive relief. It recognizes that what was once a felony might not align with current public policy or legal standards anymore. The state acknowledged its stance on handgun carrying shifted significantly. And rather than letting those past convictions for now legal conduct just linger, it created this pathway to expunge them. It's really a proactive step to align an individual's legal history with current norms, providing fairness to those caught in that kind of changing legal landscape.
Okay, our next scenario. This one deals with what sounds like a truly nightmarish situation. Being arrested for a felony because of a simple clerical error, or even worse, because someone else stole and used your identity. That's just incredibly unfair. Thankfully, Texas law does provide a path for justice here. That's under Article 55A.006.
Yes. Article 55A.006 offers a really crucial remedy for those deeply unjust situations. It allows for expunction in two main scenarios. First, if your arrest was solely the result of inaccurate identifying information because of a clerical error. Think of a typo in a database or a mix-up with someone who has a similar name or birth date. The second scenario is when the identifying information used for your arrest was falsely given by another person without your consent. So basically, someone else used your identity, and that deception is the only reason your identifying information ended up in the arrest records.
Okay, so this is really for people who were genuinely not involved in the crime at all, but got caught up in the system because of an administrative mistake or, outright identity theft. It feels like the most intuitively just path to expunction we've talked about. But practically speaking, how difficult might it be for someone to actually prove these circumstances to a court to qualify under this article?
Well, you're right. The law's intent here is very clear. Protect the truly innocent. But the challenge, often, is gathering that irrefutable proof. For a clerical error, it might involve getting, say, a sworn affidavit from the arresting agency confirming the mistake. For identity theft, you'd typically need police reports confirming that someone else was identified as the actual perpetrator, or clear evidence your identity was indeed stolen and used in that instance. The legal system, understandably, wants to be sure the record is being cleared for legitimate reasons, so clear documentation is absolutely paramount. But it does provide that vital protection for innocent individuals from those lingering shadows cast by errors or criminal deception.
Okay, what if you were arrested for a felony, but then the legal process just stopped? No charges were ever formally filed against you. Does that arrest record just sit there indefinitely, creating this sort of perpetual cloud over your head?
This brings us to Article 55A.052. Fortunately, no, it doesn't just sit there forever. Article 55A.052 provides a path for expunction if no formal indictment or information is ever filed against you. Just for clarity, an indictment is that formal written accusation by a grand jury, saying there's enough evidence to proceed to trial, usually for more serious felonies. An information is a similar formal charge, but it's filed directly by a prosecutor. Often used for less severe felonies or misdemeanors, though it's not uncommon for felonies in Texas either. So under this article, if neither of those is filed, you can typically seek expunction after at least 3 years have passed since your arrest date, especially if it was a felony arrest or if there was a felony charge arising from the same incident. But, and this is important, there's an accelerated path too. A prosecutor can actually waive that 3-year waiting period. They do that by certifying to the court that the records are no longer needed for any ongoing criminal investigation or prosecution.
Okay, 3 years still feels like a significant wait. But that prosecutor certification, that offers a real chance to speed things up. What kind of circumstances would typically lead a prosecutor to make that call and waive the waiting period?
Oh, that happens often when the investigation reveals, say, a complete lack of evidence. Or maybe the initial arrest was based on a misunderstanding that got cleared up very quickly. Sometimes key witnesses become unavailable, or maybe new evidence surfaces that completely undermines the case. In essence, the prosecutor is basically signaling, look, the state has no intention of pursuing these charges further, and it would be an unnecessary burden for the individual to have that arrest record just lingering for years. So this provision acts as a really vital safeguard against that indefinite pre-charge limbo. It ensures that if the state decides not to pursue a case, your record doesn't remain clouded indefinitely. It offers a clear timeline for resolution.
Right, that makes sense. And what if charges were filed, but then for various reasons they were later dismissed? Or maybe quashed, that's a term we hear sometimes. What happens then? And what does quashed really mean in this context? This is covered by Article 55A.053.
Exactly. Article 55A.053 allows for expunction in these very common scenarios. When we say a charge is quashed, it basically means the court has legally invalidated or thrown out the indictment or information. This often happens because of a significant procedural error, maybe a legal defect in the charging document itself, or just a finding that there's simply no legal basis to proceed. Beyond being quashed, expunction is also possible if a felony indictment is dismissed for specific, acceptable reasons that the court recognizes. And these acceptable reasons are really crucial. They can include successfully completing certain specialized court programs like a veterans court or maybe a mental health court program, or successfully finishing a pretrial diversion program. It also covers situations where it's proven the case lacked probable cause, maybe due to a fundamental mistake or the discovery of false evidence, or perhaps the total unreliability of a key witness. This is not just about the charge going away. It's very much about why it went away.
Okay, so it's not just any dismissal that qualifies. It has to be dismissals for these specific substantive legal reasons or as a result of someone's positive engagement in these rehabilitation programs. This really seems to highlight the justice system's dual role, doesn't it? Not just as a punisher, but also as, well, a facilitator of rehabilitation and a corrector of flawed processes.
Exactly. This provision really underscores the system's willingness to clear records when charges lose their legal basis. Whether that's due to a program's success, showing someone has genuinely turned things around, or due to fundamental flaws in the case itself. It promotes fairness and provides these clear avenues for second chances when someone has shown that commitment to change, or when the legal foundations of the case are just proven unsound. It allows for a more, holistic view of justice.
You know how there's often a time limit for bringing certain types of cases? That legal clock, the statute of limitations? Well, that applies here too. When that period runs out, it can actually open up another path for expunction, as outlined in Article 55A.054.
That's absolutely right. Article 55A.054 states that if the statute of limitations for the offense you were arrested for has expired, meaning that prosecution for that specific felony is legally no longer possible, then you can seek to have those records expunged. The statute of limitations is simply that legal deadline. It's a set period of time within which the state must start criminal proceedings for a specific crime. Once that window closes, they generally cannot prosecute you for it anymore.
Ah, okay. So once that legal clock runs out and the state effectively loses its chance to prosecute, the associated arrest record can be cleared. It's almost like a legal reset button after a certain amount of time passes. It offers a definitive end to that potential legal jeopardy.
Yeah, it serves several purposes, really. It promotes fairness to the accused, preventing the state from just hanging charges over someone's head indefinitely. It also acknowledges that evidence can degrade, memories fade over time, making fair trials much harder years later. What's compelling here is how the law balances the state's right to prosecute against an individual's right to move forward with their life. Once that window for prosecution definitively closes, the record can be cleared. It provides a real sense of finality and allows the person to fully move past that legal entanglement.
Okay, finally, let's explore some discretionary scenarios. Situations where the court actually has the power to act, even if the path isn't quite as clear-cut as, say, a direct acquittal or a general pardon. Yeah. These important pathways are detailed in Article 55A.101.
All right, Article 55A.101 outlines these discretionary pathways. And the key word here is a court may expunge records. That signals it's up to the judge's discretion. This happens in two main situations. First, if a person was convicted, but then later acquitted by the Court of Criminal Appeals. That's Texas's highest criminal court on appeal. So a higher court reviewed the conviction and found a legal error serious enough to warrant an acquittal. The second scenario is when an attorney representing the state, typically the prosecutor's office, formally recommends the expunction to the judge before the trial even happens.
Okay, so an appellate acquittal, where a conviction gets overturned by a higher court. That could be due to a legal technicality or maybe an error in the original trial, right? Not necessarily a finding of actual innocence, but it still opens the door for expunction. And that pre-trial prosecutor recommendation is also really significant. What might actually drive a prosecutor to make that kind of recommendation before a trial even begins?
That's a really insightful question. For the appellate acquittal, while it might be about a legal error, the system still recognizes the conviction itself cannot stand, so it warrants considering expunction. As for a pre-trial prosecutor recommendation, it could be for a variety of reasons. Maybe new evidence came up that significantly weakens their case. Or perhaps it's determined the person was arrested due to circumstances really outside their control, but it doesn't quite fit neatly into that mistaken identity category we discussed earlier. It could also be, a policy decision by the prosecutor's office, or even just a recognition that pursuing the case wouldn't really be in the interests of justice, maybe due to the individual's unique circumstances or a clear lack of culpability that doesn't perfectly align with the other specific statutes. These discretionary pathways, they really highlight the importance of that high-level appellate review and also the power of prosecutorial discretion to ensure justice and provide early relief when the circumstances truly warrant it. It offers flexibility for unique situations.
So there you have it. We've just taken a pretty deep dive into, every scenario laid out in Chapter 55A of the Texas Code of Criminal Procedure. All the ways a felony arrest or even a conviction can potentially be expunged in Texas, from beating the case in court to getting a pardon to situations involving clerical mistakes, drop charges, statute of limitations, even legislative changes. Each path offers a real, tangible opportunity for a fresh start. This isn't just some dry legal jargon we've been talking about. This is about your rights, your ability to reclaim your future under Texas law.
Yeah, and this really brings us to a powerful underlying truth, I think. In our world today, this increasingly digital world, where every bit of information feels instantly accessible, the whole concept of a truly clean slate becomes even more vital. Understanding these specific legal mechanisms, it isn't just about avoiding a record on paper. It's about reclaiming your full identity, your potential. In a society where past information can have these really profound and lasting impacts on everything, employment, housing, even personal relationships, when the law enables that true erasure of past entanglements, it can fundamentally reshape individual lives. It restores a sense of dignity. What does it truly mean for society when the law ensures that not guilty or pardoned can genuinely mean a clean slate? It means hope. It means a real chance to move forward without constantly looking over your shoulder.
Absolutely. Now, before we wrap up, a very important note for you listening. This deep dive, it's purely for educational purposes. It is not legal advice for your specific situation. The law is complex, and it's always specific to individual circumstances. For more help understanding your rights and navigating these processes, we highly recommend you visit legal-gangsta.com. Go there and download their 10-step guide to erasing your Harris County criminal record. It's packed with really practical guidance to help you understand the expunction process in detail. Stay informed, stay empowered, and thank you for taking this deep dive with us today.